Hi everyone, and welcome back to the University. Today's hearing is a bit longer. It's around 2.5 hours, so please stick with it. It's worth it. This is day 11 of the Raymond Davis trial. This is September 9th, 2019, so just a couple of days after the appointment of standby counsel. And this hearing is supposed to be about whether or not Raymond Davis's prior bad acts can be introduced during this trial. However, we start off with motions to dismiss, motions to recuse, complaints about the prosecutor, and a really icky argument, in my humble opinion, that doesn't seem to accomplish what Davis wants it to accomplish. Genuinely not really sure how he lacks so much self awareness, but we'll see what the judge thinks. I hope you enjoy.
Once I get past that point, Right there? Oh, I'm like, where did he get that?
Well, I figured if I was gonna sit here all day. The problem is, these ones sweep from everything, back and forth.
Okay, we are back on the record today for the first time in C-34296, State of Nevada versus Raymond Davis. Mr. Davis is present, out of custody. Standby counsel, Mr. Klaus is present. Ms. Collins on behalf of the state. This is the time and date set for hearing in regards to the other bad acts motion that Ms. Collins had filed. Any preliminary issues we need to take care of before we start the hearing?
Not related to the hearing, Your Honor. One of my witnesses, that I expressed my concern about her availability next week, she sent a clarifying email this morning. She's not going to be available to the beginning of the following week, so I apologize for that. I didn't understand that from what she previously sent. I thought she was only going to be gone Monday through Wednesday. It looks like she's gone through the entire week now and will not be returning home till Sunday night. And then for the record, that's Esther Brown.
Oh,
Okay.
okay. All right, so that's fine. We'll kind of plug in where we need to plug in. I don't have another trial starting. If I get a trial, it'll be through overflow anyways, so it's not like we're backed up against anything. So we're okay with that. All right, so anything else?
Yes, Your Honor.
Okay.
I want to put in a motion.
Okay.
I want to put in a motion that you recuse yourself from this case.
Okay.
I found out that you were a DA and your crime prosecution was sexual crimes against kids, which is what I'm charged with. I also learned that you had some very successful legislation, which I'm happy that you had that, but that's still to my benefits. I don't think that I can get a fair trial. I have all the respect in the world for you. I wish you the best, but with these cases, with your history, and you were working in the same DA office, I don't even know if you crossed paths with Mrs. Collins or, you know. I'm an advocate for kids' rights. I have letters here where I donated large sums of money as recently as 3-4 months ago to people.
Okay.
Kids. I'm automatically paid St. Jude's every month. They're on automatic pay. Shade Tree, women's battered shelter downtown. They're also on auto pay. I'm not this monster that she makes me out to be, you know, and you know, I feel like through these procedures that, I mean, even with when I had Mueller, I feel like I've been getting like tag team. I feel like she's been getting a lot of help, a lot of leadway, and I just don't think it's right, especially when a person's facing like 100 years in jail. You know?
So I understand your position. However, I have a ton of cases in my courtroom that deal with crimes of sexual assault, both against adults as well as children. And I feel like I can be fair and impartial and be a neutral fact finder. It's ultimately up to the jury to decide whether or not you're innocent or guilty of these charges. I feel like if I did not feel like I could be fair in these cases, I wouldn't have put my name in, nor would I be sitting here. So I feel like I can, like I said, I can be completely fair and impartial in regards to the facts. I'd also like the record to reflect that while I did work on child sexual assault cases, I stopped working in the special victims unit several years ago, and the last over 4 years of my career were actually on the homicide division. And so I literally have no idea about this case other than what you guys have told me. I've never had any exposure to this case. Don't know you, don't know the witnesses in this case, don't even know the facts of this case. So I feel like I can still be fair and impartial. Mr. Reed, remind me of the agency work that Mr. Okay. Just 1 second, I need to look at my previous notes in regards to statute or an 8th Judicial District Court rule. Do you have a written motion that you would like to?
Yes, Your Honor.
Okay, all right, go ahead. And did this written motion encompass the things that you just stated on the record?
Yes, Your Honor.
All right, so Mr. Davis is filing a defense motion to, oh no, this is a defense motion to dismiss.
It's about recusal.
I mean, it's titled defendant's motion to dismiss, but then the second part is request recusal. All right, so we could we can file that in open court. Was there anything else, Mr. Davis?
Yes, I have another motion. Also, I wanted to inform the courts, I don't know if I have to, but I read that I'm supposed to, that I would be looking to impeach the witness, Vanessa Robinson.
Okay.
She lied to a grand jury. I got 4 different lies. I got them all here. I got them all. They're not guesses. They're just flat out plain lies that's provable. So I would like to put that on the dismissal too. I would like to give the court this too.
Wait, are you asking me to dismiss the case because the witness was inconsistent, or?
Yes, her statement with the police was different from her testimony in pretrial, and her testimony with the grand jury was just totally different. I got 4 key points in that argument. When she got interviewed by the detective, she plainly stated, I can point it out to you, that she met me and I had another girl with me. That's plain, that's in the, I mean, it's right there. She told the grand jury that she was alone. I was alone. That's one inconsistency. I got 4 huge points. That's a big one. Also, she told the grand jury, she told the detective that I didn't communicate on my Facebook. I communicated with her through Facebook. I would not communicate with her on Facebook, that she would text me. And that's how she would communicate with me. She then told the grand jury that the only way she ever contacted me was through text.
So let me see if I can make sure I'm understanding this. So I guess what you're saying, there are 4 different situations where the victim testified one way at grand jury, and you have proof that those 4
Yes.
times she lied, right?
Yes.
Okay, so those are exactly what you're saying they are. Those are grounds to impeach her when she testifies. Those are not grounds to dismiss the case. So you can present those inconsistencies as long as you can do it foundationally through witnesses and through evidence. But it's just because if almost always the defense position in a case he said, she said, or she said versus she said, he said versus he said, is that the other side is lying, right? So you can't just dismiss a case because you're saying the other side is lying, but you can prove to the jury that the other side is lying.
Yes.
All right?
Yeah.
So is that a written motion?
Yes.
Okay, may I have that? All right, so this is defendant's motion to dismiss, and it is a copy of the grand jury testimony as well as the victim's statement, and it's just states that the defendant's filing a motion to dismiss. And I had explained to Mr. Davis that he is welcome to attempt to impeach the witnesses with any inconsistent statements, but that those aren't reasons to file a motion to dismiss. So we will file this, but that will be denied. Defendant's motion to dismiss that one, we gotta wait for that one.
I got another one. State's complaint is totally flawed.
Okay,
The state claims all this happened between January 25th to January the 25th, 2015. If you get the Facebook records, which I got,
okay,
because the detective in the case went and got subpoena her Facebook records. It plainly shows you on page 79 of the Facebook search warrant that allegedly I became friends with her on the 5th of 2015. That would make that in May of 2015.
okay,
There is nowhere in the Facebook search or anywhere where it says I contacted her in 2014. But all the police reports and she told the grand jury that everything happened in 2004 and ended January 25th.
wait, sorry, you said 2004.
I mean 2014.
Okay,
Yeah, she claims that's when I met her, that's when I started talking to her on Facebook. Well, the detective, I'm sure, Detective Martina Perez, who went and got the search warrant, which is right here, for Facebook, would cover the dates of first contact with her. So they gave me maybe 200-something pages of Facebook records of hers, or just her talking and whatever, talking different, but there's nothing from 2014. All of this from 2015. And the key to this is, if this is all in 2015, she would have never been 13. The alleged victim would have been 14, which changes all the charges. Because the difference between the charges somebody under 14 or somebody 14 is way more severe, the penalties. So all her charges, 1 to 9, they're all flawed.
okay, so I'm trying to follow exactly what you're saying to me. Ms. Collins, could you respond to that?
Well, I can.
Okay.
First of all, again, we should be treating this like a writ, and he should have to put it in writing and serve me. But if the court wants me to respond orally, so the charging frame in the indictment is January 1st of 2014 to July 23rd of 2015. He has a return to a search warrant in his hand where the detective only asked from January 1st of 2015. So he doesn't have, that search warrant did not request 2014 language. Also, the return he is looking at is just, does not show messenger activity. We didn't get that from Facebook.
Okay.
So you don't have to be friends with someone to message them. So what he's looking at is a date in that search warrant in 2015 where they became friends.
Okay.
So that's what he has, that's what we have.
Okay.
There's nothing else available. I mean, I assume if we went back and did another search warrant, you know, to encompass 2014,
Right.
then there might be more information there, but I just don't have that.
Yeah.
Yeah.
Your Honor, why wouldn't they do the search warrant for 2014 if they claim this is where I met her and everything? Why wouldn't they get a search warrant for that? Why
No,
would they only get a search warrant for oh, go ahead.
No, it's okay. I completely understand what you're saying. I think that the breakdown that we're having though is the points that you're bringing up, like about the victims and the witnesses, those are all really good points to bring out on cross-examination. But those aren't for motions to dismiss, because really what you're challenging here is sufficiency of the evidence,
Right.
which is what is in a petition for writ of habeas corpus. Remember, we talked about that on Friday. Those have to be decided before trial, right? I mean, when you file one of those and it cannot be heard in its entirety with giving both sides the opportunity to respond, then it waives your right to a trial within 60 days. My understanding of what you were saying on Friday is that you wish to keep your trial within 60 days, and so you'll be pursuing these avenues in regards to attacking the evidence or the sufficiency of the evidence through a trial. Is that right?
Yes, I understand.
Okay, so another thing that I need to address, and I just wanted to, when you do a motion to recuse me, it has to be heard by either the chief judge or the chief criminal judge. Sometimes, let's say, like for instance, one time I had a defendant come in and I had personally prosecuted that person in the past. So I saw that person and I said, oh, this would not be fair. I've personally prosecuted this person in the past. I'm going to recuse myself. In this situation, you brought to my attention that you would like me to recuse myself. I'm choosing not to recuse myself because I know that I can be fair and impartial to both sides and be a neutral finder in regards to the law. More importantly, I know nothing about this case. Because you've requested that, we have to halt the proceedings, and I have to have the sitting chief judge hear that motion. The problem is that has to be put on a calendar, and then it gets assigned to a different department, and then you get a new trial date. So, if that's what you're wishing to do, then I can contact the chief judge and see a time next week that they would be able to put you on their calendar and hear the motion for recusal.
Does this revoke me?
Revoke?
I mean, do I still got my 60 days?
I mean, you're not starting trial this week.
I'm supposed to be stopping trial tomorrow.
I know, but,
That's what that was told. They told me jury.
right, with me, but now you're saying, hey, I need a completely new judge. There's not a judge that just magically appears and says, all right, here's your new trial. I mean, every judge here has an entire caseload, many of which were prior defense attorneys, many of which were prior prosecutors, right? I mean,
I want to bring my own judge.
yeah. So, that's all I can really, Ms. Collins.
Your Honor, given that he was arraigned on the new indictment and the new case number, there is technically a new 60-day period that runs. I mean, he can remain invoked, we can get him in
Right.
the trial as soon as he wants.
Right.
I don't think so. They combine them, and I wasn't, they combined charges.
No, she's
They-
she's
the same
saying,
thing.
she's just saying, you still have your right to a trial within 60 days. You can stay invoked, and because of the new indictment, you can get a new 60 days. But, I mean, that's neither here nor there. I just want to make sure it's important to me that you're aware of all your rights and then the consequences of all your decisions.
Yes.
It's fine if you want to try to recuse me. It just has to be heard by a different judge.
Mm-hmm. And when would that hearing happen?
Probably sometime next week. And
Or I'm scared, I specifically thought the jury was coming in tomorrow for some reason.
they are with me.
Okay, so, okay, I would like to put that in, Your Honor,
Put what in?
this motion right here, to dismiss the evidence.
Okay, we gotta figure out this issue first though,
Oh.
because technically I wanna make sure that this is understood because if this case goes to a different judge, whenever you guys end up going to trial, they'll be ruling on these motions.
So basically, if I see a new judge, this is gonna be pushed over, and I'm not gonna get my trial this week. And I have all my witnesses in town, I paid for all my witnesses out of my pocket.
Okay, but you could have brought this up last week and you didn't, so I'm not here,
Well, go ahead.
so it's fine. Would you like me to make sure that happens?
Make sure what happened.
Get you a date to see the judge?
No, Your Honor. I'll just go with you. I'll roll the dice and go with you.
I don't want you to roll the dice and go with me. I mean, you either think that I can be fair and impartial or you don't. I mean, it's up to you. You filed the motion to recuse me. So if you want to withdraw that motion and proceed with me as is, that's fine. If you want to keep the motion, then that's fine too.
No, I'll keep the motion. I mean, I'll withdraw that motion.
Okay. The defendant's motion to withdraw me is withdrawn and taken off calendar. I just want to make sure you feel okay, right?
Yeah, I mean, I don't want to sit here. I don't want to, I mean, Your Honor, it's getting old.
Okay.
You know, I need to be, I need to go on about my life.
Okay.
I mean, instead of being a hostage in the court system and in my house.
Okay. All right. So we'll continue to move on. So in regards to that motion that you put in, may I, Marshall O'Kelly, may I please have that motion that
Yes, sure.
Mr. Davis is?
Thank you.
All right, so this was defendant's motion to dismiss in regards to the age of the victim as well as the Facebook search warrant. As I explained to Mr. Davis, I think that these are all facts that are good for cross-examination as long as he can lay the foundation. But in regards to a defendant's motion to dismiss, it's not the proper vehicle. So this motion is denied. That'll be marked as marked in, please.
Okay, I got another motion.
Okay.
I'm moving to dismiss this child due to prosecutorial misconduct. Throughout this case, Ms. Collins has led this witness, Vanessa Robinson, to change her story from the police report to pretrial to the grand jury. It has, DAs have a lot of power. They got a totally immunity. They're like next to God. They can do whatever they want. But why don't they have to answer to someone telling someone to lie? And why wouldn't a prosecutor look at all the evidence and see the mistakes and point it out? Mrs. Collins never looked at the avenue where I could possibly be innocent, which a proper DA would do.
So let me ask you, because I think we talked a little bit about this last week. Is this in regards to your stating that the victim said one thing at one point and then another thing at another and another thing at another? And so is your position that Ms. Collins had either asked her to lie or had fabricated things to her?
Yes.
Okay, Ms. Collins, your response to that, please.
My response to that, first of all, I had a discussion with Mr. Davis, with my investigator present. He brought up these same issues. I told them that those issues are ripe for cross-examination. I explained to him how cases become assigned in my office, that a report is submitted by a Metro detective and it goes to our screening division and the case is screened and charges are filed. And then they come to special victims unit if they're deemed appropriate, and then they are randomly assigned amongst the 13 lawyers that are on my team, 12 lawyers. It could have been me or anyone else that got this case. that's where it is. I mean, I'm not gonna stand here and, I have never told a victim to lie, I've never told a witness to lie, I've never told a witness to embellish. I mean, I don't know why I should even really have to defend against that. You know, he said, again, we had discussions about it today, he's been to the FBI, he thinks that I have some personal vendetta against him. I do not. This case comes across my desk like any other. I looked into Mr. Davis's background, and I've prosecuted it as I see appropriate, and that's all I can say. I mean, I don't have a dog in this fight. I go home either way, so.
Okay. So, when we had talked about this on Friday, one thing I tried to explain to you, because I wanted it to help you find some type of peace or solace with this process, is that, and it's very common in crimes, honestly not even sex assault crimes, but for a victim to say one thing to the police, and then they're asked a bunch more questions at the preliminary hearing, and then they're asked a bunch more questions at trial, and each time it changes a little bit, or each time they give more and more information. I think that that's a smart thing to bring up on cross-examination, but in regards to prosecutorial misconduct, you have to come with actual proof of something like that, right? Not just that the victim or witnesses are changing their testimony. So because of that, the defendant's motion for...
Yeah, I wasn't done reading.
Oh, okay, I apologize, I thought you were. Go ahead.
Yeah, I didn't want to interrupt you and when she got on. So,
Okay.
it's proof that Mrs. Collins said in 2004, for some reason I was not charged.
Okay.
2004, I was charged. She also said 2005, I picked up another charge. No. The court dismissed the case in 2004. Somebody came on, picked it up in 2005 again, then again it was dismissed.
Okay.
So saying that right there really hurt me to the point where she's saying that I was not charged when I was actually charged in 2004. I was charged with kidnapping, annoying a minor, all kinds of stuff. So her saying that I wasn't charged was misleading. And I think she has tried to mislead this court several times. Also, she mentioned that she looked at the victim's background. I mean, she looked at my background, and she knows the victim background. In discovery, we never got anything on the victim. She claims because she was a juvenile. But anyway, I did some searching. She is a juvenile. She has an extensive criminal record for assault, burglaries. During the time of her alleged incident that she says happened, is totally impossible. You know why it's impossible, Your Honor? She was locked up, and I was in California.
Okay, but see, those are good things for cross-examination.
Yeah. So for her to hide the fact that she knows that her victim, her alleged victim, when she made all her statements, was locked up, that she was going to jail. They were going to take her out of there, send her to jail. But she comes up with this story, and now she can go to drug rehab for her cocaine, marijuana, methamphetamine problems. It's all motive, and for DA not to look at that is just, I mean, I never heard of somebody that don't look at their alleged victim background and all this and say, wait, is this possible this could happen? Also, I handed the DA last Friday a nice little package where it's showing all of Vanessa's Facebook, and I gave her a letter, which, did you show the judge yet? I would like you to see that letter.
In regards to...
Yeah, sure. Just give her a
You know what?
Yeah, so
I'll do everything on my own. Okay, thanks.
Oh, okay. Okay. I'm sorry, I apologize.
it's okay.
I thought we was on friendly terms today.
You just have to, each of you have to address me.
Oh, okay, I'm sorry.
So, Your Honor, this came to the DA's office reception desk on Friday. It appears to be Facebook posts.
Okay.
I don't know what letter he's talking about unless I missed something in the envelope. I have, is this what you're talking about? Okay. It's an post.
Sorry, and what am I looking at it for, though? I just wanna make sure I understand. Why am I looking at it?
I think you should look at it.
No, I know, but what am I'm looking at it to consider what?
I mean, consider dismissal, consider that, you know, consider a lot of things.
No, you're talking about prosecutorial misconduct.
Right.
So there's
And this is-
nothing that's been presented to me that would, you're saying that Ms. Collins committed prosecutorial misconduct because she knew the victim was incarcerated at the time in Northern California. What proof do you have that Ms. Collins knew about that?
I'm not saying she knew I was in California. I'm saying that the prosecutor knew that the victim was in jail.
That's what I'm asking you. What knowledge do you have that Ms. Collins knew?
I did an online search on her record. I
No,
mean,
but you can't, you have
Right.
to prove that Ms. Collins knew.
So Mrs. Collins didn't know she was in jail.
Did or didn't?
I guess she didn't.
Okay, are there any other grounds for the prosecutorial misconduct?
I would like you to see that, have that for yourself, Your Honor.
Okay, I'll see it, but I don't, can I see it, please?
So,
Ms. Collins, go ahead. Thank you.
the inception of this case is that the victim in July of 2015 is picked up on a probation violation out of juvenile court. She is present in juvenile detention, and Esther Brown gives a presentation on sex trafficking and resources for victims.
Okay,
After that presentation, Vanessa Robinson, in July of 2015, reaches out to Ms. Brown, and she makes a disclosure.
okay,
Thereafter, she is revoked on her probation and goes to Caliente on her juvenile offense. She doesn't go into drug rehab or whatever he's talking about.
okay,
She is shown a photo lineup containing a picture of the defendant in Caliente in custody. So she remains in custody. The detective, as you heard during the docket hearing, continues to try to speak to Mr. Davis, tries to locate Adrian Walker, tries to figure out who China is, and finally, the warrants submitted, I think, early fall of 2016, and Mr. Davis is picked up. So in terms of her getting some kind of benefit for this that I knew about, that's inaccurate.
okay.
I know that she has a juvenile history. I am, since you were looking at those items right now, I was gonna leave that for tomorrow, but those are all bad character. Those have nothing to do with anything in this case other than to impute bad character to the victim. Again, he's held to the same standard as if he were a lawyer, and he's gonna have to have a Petrocelli hearing, and explain to the court how they're relevant, and how they apply to this case. In terms of prosecutorial misconduct, though, that is the state of the facts as I knew them. So in terms of her being incarcerated while he was in California, the only information I have about her incarceration is from July 22nd, 23rd, 2015 through the following year, because she went to Caliente on her probation violation.
Okay. All right, so I've had an opportunity to look at the photos that are these taken from her Facebook account?
Yes, Your Honor.
All right, so, a lot of I will note that a lot of these posts are bad character evidence. So there's the girls throwing gang signs, talking about being incarcerated, looks like they're doing marijuana, a lot of F the police.
Yes.
A lot of things like that. So in order for you to admit these into evidence, you are going to have to show that they are relevant, and also that their probative or that their prejudicial effect doesn't outweigh their probative value. So I'll leave you to research Petrocelli, and if you want to admit those, if you don't want to admit those, it's fine. But just so you know.
Your Honor, I wanted you to read that letter.
I did, I read it.
You read it?
Yeah,
You saw what it said?
Yes.
That's an inbox to me.
I know, I saw it.
All right.
I saw it, but, so, that's why we keep getting confused between things that can dismiss the case and things that can be brought in
Yes.
as impeachment. All right, is there any other motion?
Yes, and,
Wait, hold on one second, yes, Mr. Reed? No, no.
here's a motion for breakfast. Also in there,
Can I see that?
not only is she smoking weed or anything, she's talking about blowing up police stations. I mean, come on, are you kidding, the police? Now, Your Honor, no matter what they say about me, I did 4 years in the military. I respect the police. I respect our authorities, you know? I went to, to this day, I'm 52 years old. I never had a drink, never had a drug, and I answer and respect all my authority. But someone is saying that they're gonna blow up the police station, they want cops to die, and say, F the police and everything, and then they go back into the police and say, oh, he did this to me. It all shows horrible character, and she should have saw this.
Okay, so basically you're showing me those because you're stating that it was prosecutorial misconduct for Ms. Collins not to look at those and take that into issue?
Yes,
Okay.
yes, Your Honor.
Alright, so, the defendant's motion for prosecutorial misconduct, I already discussed that, is denied. This last one is for, Ms. Collins bringing up the fact that the defendant picked up a new case in 2004 and 2005. And as well as having the witnesses lie. Ms. Collins has made a record. I think that these issues, especially in regards to impeaching the inconsistencies of the victim or other witnesses, are best done at trial. I don't find any prosecutorial misconduct, so the defendant's motion to dismiss on that ground is denied. So I want to talk about, because you brought up your military experience a few times. And if you remember, on Friday we talked about you wearing your uniform to trial. And I just want to make sure, are you seeking to wear that during the trial, or that was just, you had worn it that day and you were just defending yourself?
No, I'm not wearing a military uniform at trial.
Okay, alright. So that's that. And then again, if you want to bring in any evidence that shows, like you said, bad character, saying you're going to blow up the police station, saying your pictures of doing drugs, things like that, we need to have a hearing outside the presence of the jury, and I want you to read the Petrocelli case and see the things that you need to do in order to do that, okay? Alright, anything else before we call in the witnesses?
No, I got more. I'm going to have this case dismissed, Your Honor. It's been a total violation of my Sixth Amendment right. My right to speedy trial has been drastically denied. This warrant was issued in 2006. Here we are in 2019. I'm a fairly easy person to find. I lived in the same place for...
Wait, I'm going to stop you right there. You remember we had the hearing on this, right? The docket hearing with all of the witnesses?
Well, this ain't the docket. I mean, I didn't...
No, that is what a docket hearing is. You're saying that it invoked your right, it's saying that you didn't have a right to a speedy trial because the police failed to arrest you within a reasonable amount of time, right?
Yes.
Okay, but do you remember that the hearing that we had with Mr. Mueller and Mr. Maynard, that was several hours long with multiple witnesses that raised this issue?
Yes.
Okay, so is that the same thing you're raising?
Yes, but also they just threw in another charge, Your Honor. I mean, they just threw in another case, so I want to just get it on the record.
Okay, so Ms. Collins, in regards to how that would apply to other cases, a new case?
I don't know what he's talking about. So this is a indictment of what was previously heard at preliminary hearing, so arguably it's a superseding indictment from what was already on file. He mentioned the other day, as this court knows, that these are the same charges. He doesn't feel like these charges go beyond what he has already seen in the discovery, beyond what he already has knowledge of. So the court's already ruled as to not it, so I believe that should apply here. I'll submit it to the court. If he wants to have another hearing again, we're not gonna be able to go to trial. So.
Alright, so defendant's motion to dismiss in regards to speedy trial, right, is denied. The court already had a lengthy several-hour hearing with multiple witnesses where we did a full analysis of dogged and how it applies to this case. And so the hearing on that motion that's already been decided will stand. So that motion is denied.
Yeah, I would like to bring in account one of her witnesses, C.C. O'Hara. It's a proven fact that C.C. O'Hara has been stalking me to the point that 6 months ago, 3-4 months ago, I went and got a police report. She came into the court of law, this jurisdiction, and she took photos of me in handcuffs in my jail guard. She gave it to the prosecutor, she has it, and then she proceeded to post this all over the internet, which has definitely violated my right to a fair trial by Las Vegas nigger Raymond Davis, pedophile arrested. This is all her alleged victim, her witness
Okay.
has posted this. And to go into a court of law and to take a picture of someone while they're in court, I didn't even know you can use cameras in court.
You can.
Well, Mrs. C, nobody told her witness, and I can show you right here, Your Honor. And I have proof that she took this, if the court would like to look at this.
So I'm sorry, this is a motion to dismiss based on what the witness did?
Yes. She has impaired my ability to have a fair trial. She has posted this to over 200,000 people online, which probably 30,000 of them is in Nevada. Her witness hasn't been, here it goes, load up. Her witness on Facebook posted all my charges, my picture in court, and everything. This is C.C. O'Hara, who's been working with the prosecutor. Your Honor, this lady has nothing to do with the case. This lady was a member of my Facebook group. She left the group and she had a vendetta against me. She borrowed money from me on 3 different occasions. This lady has nothing to do with this case other than she's been stalking me, Terry King, and I can bring 20 people in this courtroom to tell you she's been stalking us. And that's one of her witnesses. As soon as I left court Friday, Your Honor, she puts up a post on Facebook, we got his ass, all this, and oh, the prosecutor wants me in court so bad that she's willing to pay for my flight, my room, and everything. This is posted Friday when I left court. Now either Mrs. Collins is feeding C.C. O'Hara, or I don't know where she's getting this information, but every time she gets it, she publicly posts it on Facebook where thousands and thousands of people are seeing this.
Okay, but this isn't a motion, these are just.
Right, I just took the motion page off.
Okay.
Because I
So,
put, it was,
we have certain procedural safeguards in place. So we'll ask each of the prospective jurors if they've heard about this, if they know you, if they know of any of the witnesses, and if they've heard about any of the facts. If they have heard about the facts, and they can't be fair, they will be excused.
yes, I understand that, Your Honor. I would like to know, if somebody comes in court with a camera and starts taking pictures of a person and posting on social media, is that allowed in this jurisdiction? Is it?
I can just tell you that people aren't allowed to have cameras in the courtroom. There won't be any allowed in the courtroom.
So it's okay,
From now on.
it was okay before?
I don't charge people with crimes. That's up to the district attorney if they find a statute on point where someone can be prosecuted. But I personally don't charge people with crimes.
Okay.
So that motion, based on a witness taking a picture.
No, it wasn't a motion, it was a.
Or you're just bringing it to my attention?
I just
Okay.
brought it to your attention.
Okay, that wasn't a motion.
Okay, Your Honor, this is another motion. Your Honor, since this case has started, first off, I was about as low a risk
Okay,
as,
tell me what it's about first.
it's about removing this ankle bracelet.
No, okay, Mr. Davis, we've gone over this multiple times.
Yep.
We are not changing a custody
Your
step.
Honor, if a jury sees somebody in an ankle bracelet, you should know as well as anybody that it can hurt my chances for a fair trial.
Okay, so
it
I
can
want you to
hurt.
wear clothing that doesn't make that visible.
That means I can't wear slacks through pants to get them over my ankle bracelet. So if I'm standing in court, like right now, I'm being charged up. I'm pretty sure if a jury looked and saw me being charged up, it's just like bringing a defendant to court in handcuffs and having a trial. They don't do that.
That's right, they don't.
It's the
So-
same, this is a punishment. This is against me. This is a strike against me to have a fair trial, Your Honor.
Ms. Collins, have you had a case where, I have not had a case where a defendant had a house arrest bracelet on during trial out of custody, so I've never had to deal with this issue before.
I have not, but I know he can find clothing that will cover that. He's choosing right now to wear sweatpants with a tight ankle, that are tucked into, basically the top of his tennis shoes. He can find slacks that are open bottom, that are not gonna show that to the jury. Otherwise, you know, if we wanna make some accommodation where he has it taken off while he's in the courtroom and put back on before he leaves, that's the only other solution I have, so.
Mr. Klaus, as a friend of the court, could you help me out with this? Have you ever been in that predicament?
Unfortunately, Your Honor, I have not.
Okay.
I've never had a situation where someone's had house arrest bracelet on and they've actually gone to trial with that bracelet on.
Okay. All right. So, in regards to, I mean, I do agree that there's probably some right now you're wearing sweats. So that obviously, I mean, I don't think you'd wear sweats to a trial in front of a jury, but you're gonna need to find some slacks that would go over the house arrest ankle. I mean, there are lots of pants that people.
One more thing, for this. I have a bad device. I have reported it as a bad device. Every 15, 20 minutes, I have to plug this up. So while I'm in, I just wanted you to show it. See?
I get it, yeah.
While I'm in court doing trial, unless it's a 15-minute trial, I'm gonna have to plug this up and get juice. So I'm sure jury gonna see me have to plug myself up and stand here.
Okay, so what we're gonna do is I'm gonna order house arrest to provide the defendant with a new ankle monitor to which he would not have to charge up, and to also switch ankles because he does have a doctor's note that's discussing the bruising and pain to the left ankle.
Yeah.
So go in tomorrow and get that done.
Your Honor, I'd rather go to court like this. I'll just go to court like this. I'm not going down to house arrest. I don't
Okay,
wanna
Mr.
go.
Davis, then you make your bed, you're gonna sleep in it, because I cannot accommodate you,
Okay.
and then you do things like that. Like, that's ridiculous. You just asked me to help you, I'm going out of my way to help you, and now you're saying I don't want your help.
This is not helping me, Your Honor.
Okay,
This is-
all right, then motion's denied.
Oh,
Next.
okay, here it goes. This motion right here, Your Honor, it's plain to see after what Mr. Mueller had, my previous attorney had, opposed to what the state just gave me
Mhm.
in discovery, that evidence has been withheld. Not only that, evidence has been withheld. Ms. Collins has taken out certain things in certain reports like the Facebook records or whatever. She
What
has-
do you feel like you're missing?
I feel like I'm missing like at least 50 pages of Facebook records
Of what?
where the search warrant, the Facebook search warrant. I'm missing a ton of pages. This skips from one page to another page.
So, you looked at what Mr. Mueller gave you, and then you looked at what the state gave you, and now the state has given you more, right?
More.
So,
So.
is there any chance that Mr. Mueller didn't have? Go ahead, Mr. Davis.
Yeah, so basically I'm saying I'm missing things that was vital to me when Craig Mueller had it, but now all of a sudden it's in my file.
Oh, okay, so you have it now.
I have it now.
Okay, so would you like some additional time to look through it, or to
No,
go
I
through
would
it?
not. I would like to file a dismissal of this case because the prosecutor withheld evidence. I just wanted to
So let me
know.
ask you this, how do you know that Mr. Mueller never had that?
That's a great point, Your Honor. That's a great point, that maybe he never had it.
Yeah.
So, if he never, you're right on.
Like, what if he lost it?
I agree with you 100%. But the fact that even if he lost it, that I didn't have all this information that pertains to this trial, it would hamper my ability to have a fair trial.
Sure, and I'm happy, if you tell me how much time you need, I'm happy to give you that amount of time so you can go through that.
Amount of time so I can go through the missing items.
Yeah, because you have them now, right?
Yes, I have it all now.
So how much time would you like to go through those?
Can I count?
Sure.
keep the time as it is, Your Honor.
Okay. So, is that motion taken off calendar then? Is
Uh,
that motion?
I want it in the file, but
Okay, but, so, if I'm gonna file it though, then we're gonna have to talk about it, but it seems to me like you're saying you wanna keep it, you wanna keep your trial. So the basis was motion to dismiss because you don't have enough time to go through the discovery, right?
yes,
And now I'm saying, what time would you like? And you're saying, no, I don't want the time. So then, you gotta pick which camp you're at.
100 years from now. Just joking. No, I'll go with the time I have.
Okay, so that motion is taken off calendar.
I'm sorry if I
It's okay.
come across jokingly as you, I mean, this is a serious matter.
Yeah. All right. What else do you have?
That's it, Your Honor.
Okay, great. Ms. Collins, are you ready with your first witness?
I am, just briefly, so the motion he just filed, it's staying filed, or it's withdrawn? or
It's withdrawn.
It's withdrawn,
Taken off
okay, I'm
calendar.
sorry.
It's okay.
State calls Erica Munoz.
Thank you.
You want to stand or face the court? Please raise your right hand. You solemnly swear the testimony you're about to give this action will be the truth, the whole truth, and nothing but the truth, so help God. Thank you. You may be seated. Please state your complete name, spelling both your first and last name for the record.
Erica Munoz, Erica-Munoz,
I'm sorry, can you say that again?
Munoz.
Thank you.
Ms. Collins, whenever you're ready for Ms.
Thank you, Your
Munoz.
Honor. Erica, how old are you?
I'm 30 years old,
And what's your date of birth?
8/13/89.
8/13 of 1989?
Yes,
Okay. Turning your attention to June 27th of 2004, do you remember at or about that time?
mm-hmm.
Is that a yes?
Yes,
Okay. Did you have a friend named Ashley?
yes.
And how old was Ashley at that time?
13, we're the same age.
And how old were you?
13,
13. And where did you live?
in Commerce, California.
Did you travel to Las Vegas in June of 2004?
Yes.
How did you get to Las Vegas?
The Greyhound.
And where did you get the ticket from?
I don't know, actually, we got to the Greyhound and the ticket was already there.
Did you have permission of your parents did you have permission from your parents to leave the state of California and come to Las Vegas?
No, I just told my mom that I was leaving.
Okay. Were you supposed to be at Ashley's house overnight?
No, I just told her we were going, I was just gonna go with Ashley, that was it.
Okay. Do you recall telling police that you told your mom you were going to spend the night at Ashley's?
I don't remember.
Okay. Would it refresh your recollections? Look at your statement.
Okay.
May I approach the witness?
Yes.
You have a copy of this?
No, I don't.
It's provided in discovery last week, the 2004 reference. He says he doesn't have it, so.
I don't have it.
Can I get a copy? I'm sorry, I just
Yeah.
want a copy I have.
That's okay. What's the one I make a copy?
Yeah.
Because,
I'm
thank you.
Can we take a 30-minute recess while I look at the copies?
No, I mean, it's 2 pages. We don't need 30 minutes.
I'm kind of slow reading.
We're not taking 30 minutes for you to read over. And Ms. Collins, for the record, was this handed over to Mr. Mueller as part of discovery?
This was handed over to Mr. Mueller as part of the original discovery. I also duplicated my entire file and gave it to Mr. Davis on Friday in open court. I don't know why he doesn't have a copy of it.
Okay. that with, Ms. Collins, please? Whichever, doesn't matter, I just want to real quick. Thank you. All right, for the record, I'm looking at a voluntary statement of event number 040627-0471. All right, and it's a 2-page document with 30 lines of handwritten writing.
Thank you. And if you could just read this to yourself very briefly and let me know if that refreshes your recollection.
Yeah, I gotta check to that.
What's your
I mean,
objection?
she's basically giving her a police report and telling her to read it to refresh her memory.
So that's it's called refreshing recollections. So pursuant to court rules, and this will be the same for you, if someone doesn't remember something, they have the opportunity to read the document, then turn it back over, and then the recollection can be refreshed and they can answer. So that is something that is done in court every day. So if you wouldn't mind just reading that to yourself, when you're done reading the document, look up and let Ms. Collins know you've read it in its entirety, okay? Thank you.
So, Ms. Munoz, does that refresh your recollection about where you were supposed to be in terms of what you told your parents back in July or June of 2004?
Yes,
What did you tell your parents?
that I was gonna go with Ashley.
You're gonna go with
And
Ashley.
Ms. Munoz, if you wouldn't mind just keeping your voice up a little bit, you speak so quietly.
Okay.
That thing in front of you is a microphone, so if you just speak up a little bit, the microphone will pick you up.
Okay.
Thank you.
When you got to Las Vegas, did someone pick you up at the bus terminal?
No, we got, I think we remember catching a cab to the hotel.
Okay. Did you?
Your Honor, I object.
Okay?
I would like to move to impeach the witness.
And you definitely can. You have to do that when it's your turn on cross-examination.
Okay.
So after the direct examination is done, then you'll have the opportunity to cross her on certain facts she testified to, okay?
Yes, Your
Just
Honor.
keep a written list. Ms. Collins, proceed.
Thank you, Your Honor.
You're welcome.
When you got to the hotel, did you have a room?
Yes.
Okay, and you traveled with Ashley from Commerce, is that correct?
Yes.
And how did you get into the room?
We just checked in. Ashley just went to the front desk and told them where we were staying. It was the penthouse. Went straight to the room.
Okay. Did you and Ashley meet up with someone that you see in court today?
In the room, he got there afterwards.
Okay, did you see that person in court today?
Yes.
And where is he seated and what is he wearing today in court?
And then right in front of me in a white shirt.
May the record reflect identification of the defendant?
The record should so reflect.
I'd like to object to that too, the identification process, Your Honor. I'm the only one in here that will be a defendant. Obviously, unless she picks out your clerk, the only black guy in here that could possibly be the defendant is me.
She didn't say a black guy.
Well, obviously, she thinks, was it me? Obviously, I know she picked out the only black guy in court that could actually be the defendant.
There's a black man to my left.
But he can't be the defendant,
Okay.
I'm pretty sure.
Your objection is noted for the record. It is overruled. Go ahead and continue, Ms. Collins.
When you got to the room, did the person you identified in court come to the room after you arrived or was he already there?
No, after we arrived, he was there.
Okay. And did you learn his name?
Yes.
What was his name?
Raymond.
Who introduced you to Raymond?
Ashley.
Ashley Heredia?
Yes.
Okay. And did you all stay in the same room during your time in Vegas?
Yes.
And Mr. Davis stayed in that room?
Yes.
What were the sleeping arrangements?
I think I remember us being all in the bed.
When you say all in the bed, who are you referring to?
Raymond, Ashley, and I.
Okay. Were you offered money by Mr. Davis?
I was offered money by Ashley from him,
Okay. For what?
to either dance for him or let him touch us
And where would that have taken place?
there at the hotel.
Did you take a shower while you were there?
Yes,
Did you take a shower with someone?
yes, with Ashley.
At whose request was that?
I was in the shower first, and Ashley jumped in after with me.
And where was Mr. Davis?
He was not there yet.
He was not there yet?
No, we got there, we took a shower, and then I remember him being there after we got out of the shower.
Okay, and what happened after you got out of the shower?
That's when Ashley told me that, that she was dancing for him, or he was giving her money for favors, what she said.
What kind of favors?
Sexual favors, touching her.
Was Mr. Davis there when you had that conversation with Ashley when you got out of the shower?
He was there, yes.
Okay,
Sorry, do you mean like there as part of the conversation or just in the room?
in the room.
Okay, got it.
He was in the room?
Mm-hmm.
Is
Yes.
that a yes? Okay. Did he become part of the conversation?
Yes, after we got out of the bathroom, he was sitting on the bed.
Okay, and did he speak to you after you got out of the bathroom?
Yes.
What did you talk about?
He was sitting on the bed, and Ashley and I walked towards him, and I immediately knew that this wasn't okay. And he was, waiting for us to come up to the bed towards him.
When you got out of the shower with Ashley and did you walk out of the bathroom and go into the sleeping area?
Yes,
Did you have clothes on?
yes,
You had already put your clothes on.
yes,
Did Ashley already put her clothes on?
yes,
Okay. And you said, Mr. Davis, you had both of your hands up and you were,
no, we were holding hands, me and Ashley were holding hands.
okay. You and Ashley were holding hands, and what was Mr. Davis doing?
Sitting on the bed.
Okay. What was his attire?
Oh, I don't remember.
Okay. Now, you said there was a conversation about doing things for money, is that a yes?
Yes,
In front of Mr. Davis between you and Ashley.
yes,
Was that at that same time you got out of the shower?
yes, when we walked towards him, towards the bed.
Okay. And did Mr. Davis do anything to acknowledge that conversation?
No,
or-
she just said that when she came out the shower, they got fully dressed, and then I showed up. I mean, it's gotta be one or the other. You can't just go with both of them. I can't be there and show up at the same time.
Okay, can you just clarify, Ms. Collins, please?
When you got out of the shower and you and Ashley hand in hand are walking out of the bathroom, is Mr. Davis on the bed or does he arrive after that?
He was on the bed.
Okay, so when you said previously that he wasn't there, is that because he arrived sometime during the time you were in the shower?
Yes,
Okay, so you have a conversation with Ashley about doing things.
Your Honor, I object. That's not what was said. What was said is when you got out the shower, you got dressed, and then you held hands with, talked to Ashley or whatever, and then I showed up.
Okay, well, I think she just clarified, but I'd be happy to have you clarify on cross-examination, but for right now, the objection is overruled.
Okay.
Go ahead.
You had a conversation with Ashley that was about money for being touched by Mr. Davis, is that
yes,
correct?
yes.
Okay. And was Mr. Davis was present for that conversation?
When we walked up to the bed, yes.
Okay. And did Mr. Davis in any way acknowledge that conversation or affirm in any way that he would give you that money if that conduct were to proceed?
No, he was just, when we walked up to the bed and Ashley was saying that he would give us money, he was rubbing my arm.
Mr. Davis was rubbing your arm?
Yes.
Okay. Did he say anything in response to?
I was crying.
Okay.
I knew what was going on at that point.
Okay. Did Mr. Davis say anything?
He said, "You're okay, I'm not gonna hurt you."
Did he ever say anything in regard to, no, that's not true, or no, I'm not gonna give you and Ashley money?
No.
Do you remember the amount that he was gonna offer you?
No, I do not.
Okay. Did you sleep in the same bed that he did?
Your Honor, I object. She just said she don't remember the amount she was gonna give me, but in her written statement, she said that Ray said he was gonna give us $1,000.
So those are things for cross-examination.
Okay.
Okay, go ahead, Ms. Collins.
Did, I forget my question. I apologize. When you slept in the same bed with Mr. Davis, was everyone clothed or unclothed?
Clothed.
Okay. Was there a request for you to sleep unclothed?
No.
Okay, did you talk about sleeping naked with him in your statement that you just read? Do you remember that?
In the statement, yes, I read, yes.
Okay, so explain to me the context of sleeping naked in the bed. Was that a request or?
I don't remember.
Okay. Since Mr. Davis brought it up, you said you didn't remember the dollar amount that you were offered for particular things? Is that correct? You do not remember?
No, I don't remember.
Would it refresh your recollection to review your statement again?
You just gave her the statement, I object, Your Honor. She just gave her to refresh.
Ms. Venus, would looking at that statement help refresh your recollection as to what you told the police?
Yes.
Okay, then the objection is noted for the record, it's overruled. Allow Ms. Venus opportunity to look at that, please.
Your Honor, if you could just instruct Mr. Davis, today might be a good time that he can't speak under his breath while being
Your Honor,
on
I'm
the
talking to
stand.
I'm talking to my wife. I'm not allowed to.
You can, you just have to keep it quiet, because the jury can't hear what you're saying when they're in here.
Does that help you remember, Ms. Munoz?
Yes,
As to what you told the police, what did you tell them?
that if he would touch us, that he would give us $100. I mean, $1,000.
Okay, and was there another amount offered as well?
Yes, $100.
Okay, and what would the $100 be for?
Just for him to touch me.
Sorry, what was the $1,000 for?
For him to touch them.
That, what was the 100 for?
If he didn't touch them, he would just give them 100.
Got it, sorry.
Now, were you willing to engage in any of this behavior with him?
No, not at all.
Okay. Did you see Ashley engage in any of this behavior with him? Either dancing for him, or sleeping naked with him, or allowing him to touch her while you were there?
No.
Did, you mentioned earlier that you were crying when this, is that yes?
Yes.
When this topic came up?
Yes.
Why were you crying?
Because I told Ashley that I was raped a couple months before, and I didn't want anything to happen to me.
Okay. And what happened after you became upset?
That's when he was rubbing my arm and told me that he wasn't gonna hurt me, and I walked away.
Okay. Did you stay in the room, or did you go somewhere else?
That night I stayed in the room.
Okay. Did you eventually leave Ashley and Ray and go off on your own?
Yes.
Where did you go?
My friend Mallory was in town with her family, so to get out, I went with her.
How many days did you stay in the hotel with Mr. Davis and Ashley?
It was just that night, and the morning after.
Is the morning after when you went to find your friend Mallory?
No, it was that night after that I went to go find my friend Mallory.
Did Ashley have marijuana while you were in Las Vegas?
I don't remember.
Okay. Did you see the defendant with marijuana while you were in Las Vegas?
I don't remember.
Do you remember whether or not you smoked any weed with Ashley while you were here?
No, I don't remember.
Do you remember talking to police when you were here in Las Vegas?
Yes.
And after you talked to the police, did you go back to Mr. Davis, or how did you get home?
I went back to the room and I was locked out. That was before I talked to the police.
And when you were locked out, did you ever get back in the room, or what happened?
No, I did not.
Did you return to California?
Yes, I did.
How did you get home?
My mom and my dad picked me up.
Okay, did Ashley go home with you?
No, she didn't.
And did you use the bus ticket supplied by Mr. Davis to get home?
No.
Just to go back, was showering at the same time as Ashley, is that something that you guys did previously? Had that ever happened before?
No, Ashley just seemed nervous. When I got in the shower first, we had our bags in the restroom, and when I was in there, she jumped in with me, but she looked nervous. She stacked up the bags by where the door was at to come in and out of the restroom, and she jumped in. I don't know why she was nervous at that point.
Did you ask her to get in?
No.
Okay. Nothing else, yeah.
Mr. Davis, cross-examination?
Yes. How old are you?
I'm 30 years old.
You're 30 years old. So you took a bus when you were 13, and you recall a hotel name, right, that you stayed at?
Yeah.
What's the name of the hotel?
I said the Caesar's Palace.
It was Caesar's
The
Palace?
Caesar's Palace?
The hotel that you were staying in was Caesar's Palace?
That's what I thought it was, yes.
Your Honor, I would like to
No,
know.
you have to ask questions, you don't just get.
Okay, the hotel in the police report is the Plaza Hotel. That's not Caesar's Palace, you understand that?
Your Honor, can we have her say yes or no for the record? I'm sorry.
Sorry, it's hard to
Yes.
get used to, just say
Yes.
yes or no.
So, why would you say you were staying at Caesar's Palace? I don't understand.
It was a long time ago, that's what I remember. I just remember something with the P.
Caesar's Palace? I guess Palace do have a P in it, so does Palazzo. So wouldn't you know if you caught the cab from the Greyhound bus depot to Caesar's Palace?
Ashley called the cabinet, so I don't know.
So Ashley called the cab, and you took the
Yes,
and you took the Greyhound bus, right?
yes.
The Greyhound bus depot, Your Honor.
Okay, hold on, we gotta make sure.
Right.
So right now, we're just doing
Right.
witnesses.
Yes.
Arguments towards the
Okay.
end, okay? So you gotta finish with her question.
Okay, so you took the Greyhound bus, and then you took a cab to the plaza,
Yes.
right? Cab to the plaza from the Greyhound bus depot. So, when you got out of the cab and you went to the front desk to get a key for your room, am I
Yes.
correct?
Yes.
How would you get a key to somebody else's room if you're 13 years old? Don't they make you show identification?
I didn't actually got the key.
Was she 13 too?
Yes.
So you go up to the room, and was the defendant there?
No.
He wasn't. At what time did the defendant return?
During, we were still in the bathroom.
But you said when you were still in the bathroom taking a shower together, I had returned?
Yes.
But your statement to her
Well,
was you got out of the bathroom, out of the shower, you got dressed, sat on the bed.
No.
You know, that's what you said.
No.
Well, objection argumentative and compound.
Okay.
So sustained, so just break it down piece by
Right.
piece.
Okay. So now, the defendant leaves you guys, and your stay was one night, you're saying, right?
Yes.
You stayed there one night.
In the room, yes.
Okay. What night were you arrested?
It was the next night.
It was the next night?
Yes.
How could it be the next night if you said you stayed there one night?
Because I didn't stay there. I was out with my friend, and when I went back to the room, I was locked out.
Have you ever been Do you have any mental issues?
No.
Objection, relevance.
The relevance is, in the police report, it was noted that she was a mentally retarded 13-year-old.
Okay, so that's overruled, you can proceed with the question.
Okay. So, you guys took a shower, no?
Wait, no, it was overruled, which means you can ask that question.
Okay, so you've never been mentally, you never told the police or nobody ever told the police you were mentally ill?
No.
So if we bring up that police report, so the police lied and said you were mentally ill.
No objection.
Assisting.
Okay. So, when the defendant took off, how many hours was he gone that day?
I don't know.
Can you take a guess?
What day are you talking?
Speculation.
I just asked her to take a guess.
So no witness can speculate. So if she remembers, she can state it. If she doesn't,
So-
she can't guess.
So so I took off in the daytime. At what point in time did I come back?
What day are you talking about?
It was only one day. You stayed at one day?
Stay one night.
Yes.
It was around 11 o'clock that night. So when we got there, it was 11. It was around 11. It was almost 12 o'clock.
Okay. Your Honor, I would like to, I don't want to ask her any more questions.
Okay, so then we'll address any issues after she's left. So if you're done, you can sit down, and it's Ms. Collins' turn to do any of the
Okay.
directives she hasn't.
Okay.
And then we'll address any issues after the witnesses.
Yes, sir.
Court, you could just indulge me for a second, I just want to make sure, I'm not seeing the mentally
Okay.
retarded reference.
Well, you're doing that. If you don't, I am a little confused about a point. When you state that you're holding hands with Ashley and you're walking towards the defendant, and you're having this conversation about the money for acts, are you guys engaging in this conversation with Mr. Davis? Are you having the conversation
With each other.
with each other?
Yes.
And is he in close proximity? Like, can he hear you, or you
Yes.
don't know if he can hear you?
No, he was right, almost right in front of us.
Okay, but he's not saying anything.
No, Ashley told him that I wasn't gonna do anything.
Okay, so Ashley informed him in front of you
Yes.
that you weren't going to do anything.
Yes.
Did she say anything in regards to what she was going to do?
No.
Okay, so this conversation was had in his presence?
Yes.
Okay, I was confused about that. So, Mr. Davis, that was a point of confusion for me. Do you have any follow-up in regards to my
Yeah.
question?
After Mrs. Collins is done with her, after my argument, I would like to call her back to the stand.
Okay.
If he's got more questions,
Yeah.
go
Well, I
ahead.
would like to let her.
Well, she's still working, so we're gonna make the best use of our time. So go ahead and ask her any questions if you have any.
So I just want to emphasize again that you have no recollection of where you got the ticket from, right? You don't know where it came from?
We picked it up at the Greyhound.
Okay, and then, I mean, it's only one Greyhound in Vegas, right?
We picked, no.
No,
we
in
didn't-
Vegas.
I
Hold
picked
on,
up,
let her finish and then you can
we
start.
picked up the Greyhound ticket at Union Station downtown Los Angeles to come up here.
Right. And obviously they dropped you off at the Greyhound bus depot.
Yes.
Okay. I'll let Ms. Collins finish.
Ma'am, are you aware that there's actually 3 Greyhound stations in Las Vegas? Do you know that?
No.
Mr. Davis made a reference and said that the police report indicated either something that was reported by you or the police indicated that you had a mental issue back at that time. Is that true?
No.
Okay. I'm not seeing it in the police report, so I'm gonna ask Mr. Davis to show me what he's looking at.
Well, if you look up the 2004 charges, Your Honor, it will say, it will tell you with a mentally ill charge, in the charge it was mentally ill.
Okay, so, just so the court knows, if I may.
Okay.
He was charged with annoying a minor, so annoying a minor encompasses that language. So it does not say in a police report anywhere that she was mentally ill. That is just the all-encompassing nature of annoying a minor, just so the record's clear.
I understand.
Okay.
Sounds good.
And I thought I clarified it for the judge, and apparently I didn't. So the conversation about $1,000 to let him touch you, or $100 to sleep naked with him, that was in the bedroom with Mr. Davis present?
Yes.
Okay, and the proximity, how close were you to him, just for the record?
Maybe from me to you.
All right, so the record will reflect that from where I am sitting to where Ms. Munoz is sitting is probably like 6 feet, I don't know, 5 to 6 feet.
It's 8 feet, yeah.
6 to 8 feet.
6 to 8, sounds good.
Again, he was in your presence.
Yes.
Nothing else.
Do you have anything based on those questions, Mr. Davis?
Yes, Your Honor. So, what's funny about this is,
No questions.
okay, so, you were never touched though, right?
No.
You never got naked?
No.
You never put on a shower show?
No.
So, were you kidnapped, held against your own wishes?
No.
So what was discharged in 2004? If she wasn't,
Okay, hold on, so we can have argument afterwards, but we need to stay within the procedural guidelines.
so you wasn't kidnapped, no one touched you, you didn't put on a shower show,
Okay,
Well,
hold on,
objection.
ask one at a time, okay?
okay, so you wasn't kidnapped,
Answer.
No.
you were not touched,
No.
you did not get oral sex to anyone.
No.
That about covers it.
Okay, you done?
Yes, Your Honor.
All right, anything else, Ms. Collins?
No, Your Honor.
Ms. Munoz, you're free to go. During the pendency of this trial that's about to start tomorrow, just please don't share your testimony with anyone else until the trial has concluded, okay? Thank you, I appreciate it. Ms. Collins, you're, please feel free to call your next witness.
State calls Haley Ferris. I think my investigator was here.
Okay.
What's your second? Step up. Remain standing and face the clerk. Please raise your right hand. You solemnly swear the testimony you're about to give this action to be the truth, the whole truth, and nothing but true self you got?
Yeah.
Thank you. You may be seated. Please state your complete name, spelling both your first and last name for the record.
Haley Ferris, HALEYFARRIS.
Ms. Collins, your witness whenever you're ready.
Thank you. Good afternoon, Ms. Ferris. How are you?
I'm okay.
Good. How old are you?
I am 25.
I'm sorry?
25,
And what's your date of birth?
May 2nd, 1994.
Are you from here in Las Vegas?
Yes, I am.
I want to turn your attention to May of 2011, specifically May 2nd of 2011. Did you live here in Las Vegas?
Yes, I've lived here my whole life.
Were you a runaway at that time?
Yes.
While you were a runaway in May of 2011, did you hang out anywhere in particular?
I was panhandling quite frequently down on Fremont Experience.
And when you were panhandling, would you do that alone, or would you do that?
It would vary. Sometimes, most of the time I did it alone, but this time I had a friend with me. Her name was Ayla.
So in 2000, if you are 25 now, in 2011, how old were you?
I was 15 going on 16 actually that day specific.
And when was your birthday?
May 2nd, 1994.
So you were out panhandling on your birthday then?
It was the day right before my birthday. The night I got arrested, like, it just barely, like, was around midnight. That was when I turned 16.
So, May 1st, then, you were panhandling.
Yes,
Okay. Down on Fremont Street.
yes,
Did you come into contact with anyone you see here in the courtroom today?
yes, I did.
Where is that person seated and what are they wearing today, right now in court? Can you tell me what that person's wearing?
White shirt.
May the record reflect identification of the defendant?
It will.
How did you come into contact with? the
We were
defendant?
panhandling and he asked us if we were hungry.
Who is
So,
we?
me and the girl Ayla.
Are you saying, I'm sorry, Ava or
Ayla.
Ayla, okay.
Ayla Hale, I just added her on Facebook too to talk to her about it.
Okay. So, you were panhandling with Ayla, you said Fremont Street experience, where at in that vicinity, do you remember?
The experience. There was like the, what do you call it, Golden Nugget and all the places right there.
Okay. All right,
Sorry, no worries.
can't break those, trust me.
Yeah, we're good.
So after you were panhandling, you said you ran into this person that you've identified in court. Was it daytime, nighttime, something different?
I swear to God, I shut it off.
That's okay, just turn it off and then
It was daytime. It was like morning.
And who struck up the conversation? You or
He
him?
struck it up. Because he came up to us while we were panhandling.
And when he came up to you while you were panhandling, tell me what happened.
He asked us if we were hungry, and we said yeah, so he bought us breakfast.
Do you remember where he bought you breakfast?
I'm not quite sure which place it was right there, but it was down around Fremont Experience.
Did he buy you food and bring it back, or did he go somewhere with you or something different?
No, he wound up getting, well, we went up to his hotel room, because he said he had weed. And so we went up to his hotel room. He said he didn't smoke weed though. So I found that kind of odd, and then some other things happened.
Okay.
And then he bought me a phone, and he bought the hotel room, and we were going to come back that night.
Okay, you're getting way ahead of me. Just 1 second. So you said that he bought you something to eat. Did you
Yeah.
go with him, or did he bring food back
Yeah,
to
no,
you?
we were eating at a table inside the place.
Inside one of the hotels?
Yeah.
Okay. And
It was
so
a casino, not a hotel, like one of the restaurants inside of the casino.
So just 1 second, everything that you're saying is gonna be recorded, or it is being recorded, and then it's being typed out. So, if
Ooh-wee.
you- it's okay, so if you guys talk over each other, it's really hard for them to type it out. So these are things that we don't have to worry about in the real world, but once we come in here, it's hard. So don't worry about it, it's hard to get used to. Just make sure you're able to finish everything, and then once you're done, Ms. Collins is going to start, and just let her finish, okay? And that way I'll be able to get a clear record.
Okay.
All right, thank you. Ms. Collins?
So you said you were at a table in a casino restaurant?
Yeah.
And what happened after that?
And we went up to his hotel room.
Do you remember what hotel his hotel room was? What hotel he was in?
Not really.
Okay. So you and your friend Ayla went to his hotel room? Is that a yes?
Yes.
Okay. Is that when he offered you weed?
Yeah. Well, he brought up the weed before we even went up
I
there.
object. Mrs. Collins, you can't tell her to say yeah. I mean, she can say yes or no, or
I'm sorry, Mr. Davis, I didn't hear, could you stand up for me? I'm sorry, did,
Well, the prosecutor is telling her to say yeah. I mean, when she's leading her, if you ask her a question, let her answer it instead of jumping over her and saying, tell her, say yeah to the defendant.
okay, so I didn't hear that, but I'll watch for it,
Yes.
but right now, I didn't hear that, so the objection's overruled. Ms. Collins, go ahead, please.
I think she said mm-hmm, and I asked her to say yes or no, so it wasn't.
I shook my head.
Oh, she shook her head.
So just go ahead and answer.
Yeah, that's what she was saying.
Okay, I got it, go ahead,
So I wouldn't hear anything.
go ahead, Ms. Collins.
So you went up to his room and you talked about the weed before you got to his room. Is that a yes?
Yes.
Okay.
Yes, sorry, I'm sorry.
That's okay. When you went, the hotel room that you went to, did you have to walk from the restaurant, do you remember?
Yes.
And when you went to the hotel room, did you have to use an elevator to get to his room?
Yes.
Okay. And when you got to his room, was anyone else there?
No.
So it's just you and himself and Ayla?
Yes.
Okay. What's the first thing that happened when you got to his hotel room?
Well, he brought out the weed.
Did you guys smoke some weed?
I did, and Ayla did. He didn't.
So Ayla did, you did, and he did not.
Yes.
Okay. And what's the very next thing that happened?
Well, she was kind of scared before we even went up there. So he had propositioned us. I don't remember exactly what his words were or what the proposition was exactly, but I know it involved her and she was scared. So she didn't want to do anything, so then I kind of like put her off to the side because she was still scared and she didn't want to be there to begin with. And we had worked out a proposition of some sort to where I got the hotel room later on.
Okay. So I'm going to ask you some questions about that. When you said he propositioned her and she was scared, what do you mean by proposition?
Like well, we're both runaways, so we don't have anything. We don't have any money. We don't have no nothing. So he basically like said that he could make that change by like, for example, I had a phone after that. We had a hotel room which had, hot running water, other things that we didn't have while we were running away. So that's what I mean by he propositioned us. We do something for him and he would help us out.
Okay, so what did he want Ayla to do that was making her scared?
I don't remember. I kind of like blocked out a little chunk of that, and it's been a while.
Okay, and what did he want you to do?
All I remember is that we wound up doing something sexually that I prefer not to. I don't like saying anything.
Okay, when you say we, who are you talking about?
Me and him.
Yourself and the person that you identified in court
Yeah.
today? Okay, I understand that you prefer not to say, but this is a closed proceeding and I need to let the judge know what happened. So if you could just describe very briefly what transpired between you and the defendant.
As far as I remember, I gave him oral sex. As far
And did that happen in his hotel room?
Yes. Something else was supposed to happen later on, but it didn't. I got arrested.
What else was supposed to happen?
I'm not quite sure.
Okay.
I got arrested.
All right, so let's back up for a minute. You said that you got a cell phone. Is that a yes?
So I can contact him once I got back down, and yes.
Once you got where?
Back down to Fremont Street
Okay.
Experience.
And you said that he got you a hotel room.
Yes.
Where did he get you a hotel room?
I think it was the Las Vegas Club, something like that. It's torn down now.
Okay. And did he go in, was this before the things that happened in his room or after the things?
After.
So did he walk you to that hotel and?
Nope.
Okay, how did he get the room for you then?
Well, he got the room somehow, and he told me which room it would be at. He handed me the keys, and that was about it. Like, we just talked over the phone, and then I wound up getting arrested.
Okay, we're getting there.
So
So, was that daytime or nighttime then that you checked into the hotel room?
this was nighttime. It was later on in the evening.
Okay. And the cell phone, did he take you to a store to buy that?
It was a California number. I'm not quite sure where the cell phone came from.
Okay, was it new in a box or was it
I
just?
can't remember.
Okay. But it was a California number you said? Is that a yes?
Yes, sorry.
Oh, that's okay. And you've mentioned getting arrested.
Yes, for curfew.
Okay. So this is the late evening hours of May 1st going into May 2nd of 2011.
Correct.
Okay, and you were going to turn 16? Is
Yes,
that
correct.
On May 2nd?
Yes.
And you said you were approached and arrested. Can you tell the judge what happened?
I was walking to actually go meet back up with him, and I believe we were on the phone. So the hotel that we stayed at, or that I stayed at, was across the street from where he was at. So I was walking towards where he was staying to go meet back up with him, and I got stopped by the Fremont Street Experience police.
And what were you stopped for?
For curfew?
Too late for you to be out alone.
Yes.
And how do you say your name again?
Haley.
No, your friend's name.
Ayla.
Ayla. Ayla wasn't with you, correct?
No, she didn't come back up there with me.
And when you got stopped for curfew, you said that you had been on the phone with.
Yeah, I was on the phone with him, and then he hung up on me.
Okay. Did you try to contact him again?
Yeah, to try to make him lie for me so I didn't get arrested. And he didn't even answer the phone after that, and I never seen him since.
So the oral.
Your Honor.
1 second, is there an objection?
Object?
Yes, what's the objection?
Yeah. I don't understand the phrase, could she rephrase the term, trying to make me lie for her? I don't understand what was.
So I want you to ask that on cross-examination,
Oh,
okay?
okay.
When you called Ray, did you, were you trying to not get arrested for curfew?
Correct.
So when
I
you
was a
said
runaway.
you were a runaway? So you wanted him to vouch for you so you wouldn't get
Correct.
fucked up?
I figured since it was a dirty business to begin with, that maybe he would lie for me so I didn't get caught up.
The oral sex that you mentioned that happened in the hotel room, that was only one time?
Yes.
I'll pass it.
Mr. Davis?
How is it that you remember these dates?
Excuse me?
The dates, you said May the 2nd, 2011. How do you remember these dates?
I don't remember the year exactly, I just remember the day because it was my birthday.
Okay. So, in the police report,
That's what reminded me of the exact year.
so you
was
remember the police report, and do you remember,
Well,
What age-
objection, she's never said she didn't remember the police report.
no, I didn't say that.
What did you say?
I didn't say she didn't remember the police. I said, how did you remember these dates so easily?
Okay.
So,
You remember your birthday, right?
sometime,
There you go.
you know. But, what, so what's your birthday again?
May 2nd, 1994.
May the 2nd, 1994?
Correct.
Okay, in the police report, it said you were turning 17 that day.
And no, I was not.
I would like to,
It says I was
Sure.
turning 17? There's no way.
can you take that to Shirley?
Are you asking to refresh her recollection?
Yes, I'm gonna let her read it.
And what is that?
It's the police report.
No,
I mean, it's
that's-
the statement where it says she's 17. It's right there, I circled it.
Okay, but hold on, what are you showing her?
It's my
It's a
motion.
motion to admit evidence
Okay,
of the crimes.
that's something that she hasn't seen. You're not gonna be able to refresh your recollection with her because that's a motion. Do you have a police report that you'd like to show her?
No, there was never a police report. So, when the officers arrested you, you didn't tell them anything about the defendant?
You?
Yeah.
I might have told him I was trying to get away from you or something like that.
So you lied to the police?
After.
So
Yeah.
you lied to the police to say you were
Yeah.
trying to get away from me, to make
Yeah,
excuse,
kinda.
to basically make an excuse for yourself,
Correct.
so you wouldn't go to jail.
Correct.
Yeah.
Well, I wouldn't go to jail either way because I was a minor.
Right. So,
And I was a runaway, so I just went home.
where did Mrs. Collins find you at?
Excuse me?
The prosecutor, where did she find you at?
My house.
So she went to your home, she contacted you.
Yeah, a good thing.
She promised you anything?
No, hell no.
Hell no.
I mean, heck no, sorry.
Are you under the influence right now?
Excuse me?
Are you under the influence?
No, I'm not.
Do you
Thank
take
you.
drugs?
I smoke
Objection.
weed.
Have you ever been arrested for drugs?
Excuse me?
Objection.
Okay, so there has to be,
Okay.
or what is the relevance of that question?
I'm going to a relevancy that I think this witness is stoned out of her mind right now, high, and it's not marijuana.
Just,
She's very
1
fidgety,
second, don't.
she's very fidgety, and she's very moved. I don't think she's very coherent of what's going on. She don't understand what's going on in this court.
Okay, so your question though was, has she ever been arrested for drugs?
Yes.
That's not a relevant question for the purposes of this hearing, so that's sustained, move on to a different question.
So, you were gonna call me, you admitted that you were gonna call me to try to get you out of the trouble that
I
you were
did
in
call
for
you, you
curfew.
didn't answer.
I didn't answer? And you said the hotel that you were staying in is probably tore down now, right?
No, it is torn down.
It is tore down? Did you know in that police report that they said this all happened at the Four
So
Queens?
sorry, apologies.
That's
You
where I
said-
got stopped.
1 second. You said that there was no police report, so
I
is
mean,
there
in
a
the-
police report or?
It said somewhere in her thing that, I saw it somewhere that it said the Four Queens was the hotel, and Four Queens is still up.
Okay, so just ask her, is it possible that this was at the Four Queens?
Is it possible that it was a Four Queens?
That's where I got stopped, I believe. It was in front of the Four Queens.
You got stopped in front of the Four Queens, the room wasn't in the Four Queens?
I'm sorry?
The room wasn't in the Four Queens?
I'm not sure which hotel it was that I was staying in. I think it was the Las Vegas Club. Or the California Club, one of those two. It was a state name, like one of the states. But I'm pretty sure it's turned on now.
Okay. Sounds fair. I got no more questions for her.
Okay, Ms. Collins, you direct?
I did not personally come to your house, is that
No,
correct?
you did not.
Okay. Did my investigator go to your home? and-
Yes.
Okay.
No, no.
The lady that's in
Yes,
court?
yeah.
Okay.
So
No.
I'm gonna let the record reflect that the witness just nodded her head to a female that's sitting in the front row, who Ms. Collins just identified as your investigator, is that correct?
That is correct.
Okay, go ahead.
Haley, and perhaps I'm doing the math wrong, but I do the math, so you were born May 2nd, 1994.
Correct.
Wouldn't that mean that in 2011 you were turning 17, not 16?
I mean, because a lot of things happened after that I figured I wasn't, but, I mean, if that's what the police report says the date was, then I mean, my times can be off.
Okay. But that doesn't change, other than the time being off, that doesn't change anything else you guys.
No, my timing is off on a lot of things.
Thank you.
Mr. Davis, is there any follow-up you'd like based on those questions?
Yes, Your Honor, so, I mean, basically, her admitting and being off on a lot of things and giving the wrong
Did
age.
you have any questions for her?
I mean, no more for her.
All right, so, Haley, a few questions. When you stated, so when you got arrested, or not arrested, when you were made contact with Metro on that night, did you ever have telephonic conversation with Mr. Harris, or he just didn't answer, period?
I'm sorry?
Mr. Davis.
Mr. Davis.
Yeah, I was
sorry.
like, Harris, that's my boyfriend's last name.
Oh, no, that's okay, Mr. Davis, I apologize.
Yeah, actually, I was on the phone with him when I got stopped, and then he hung up on me when I was like, oh my gosh, I'm getting stopped. And
Oh.
then I called back and he didn't answer after that.
Okay, sorry, that's where I was a little bit confused. And then the last question I have for you is when you stated that there was supposed to be something else that was gonna happen later that evening, I know you said you didn't remember the specifics, but was that something sexual or something else?
Well, it had to have been. I mean, that's the kind of thing that he was trying to do. I think he was really going for the girl I was with, but she's just, I mean, it just wasn't gonna happen.
Okay, so as you sit here today, do you have any memory of whether or not that thing that was gonna happen later was sexual or not?
Yes, I'm pretty sure it was sexual. I'm
Okay.
almost positive.
Okay, all right, so sorry, those were the things that I didn't have clarified. Does anybody have any follow-up based on the court's questions for purposes of this hearing?
Your Honor,
Just questions.
Well, questions.
We're gonna have arguments later.
so when you say, Haley, when you say something sexually was gonna happen, where did I go that I still wouldn't be with you guys? Do you understand?
Excuse me?
Objection, calls for second.
You're saying I wasn't there and I was
Sustained
coming.
as the question is now, but rephrase it.
You're saying I left, at some point in time I left and was gonna come back, right?
I left.
You left.
Me and my friend left on our razor scooter thing, back to where we were staying, in the area we were staying at, because we didn't stay on Fremont Street Experience. We stayed on the north side, like Anna Decatur area.
So
So we went back over there, and then we had the phone, so I can contact you. And we were in contact that way, and then you let me know when the hotel was ready. Then I went back down there. So I didn't see you again up until, actually I didn't see you again after that. There's this phone call.
So did the police contact you and try to get a report from you, or did you ever tell the police?
What do you mean?
I mean, what the DA is doing is saying that there was some kind of crime committed, so.
Objection.
Nobody said that.
Okay, so just address your questions to her. Don't say what the DA was trying to say, just ask your question and then she'll answer, and then we can argue later, okay?
Hey, were you forced to do anything against your will?
By you?
Yeah.
No.
So I didn't force you to do anything?
Not against my will, no. You might have scared us inside, but no, I know better than to try to react differently than to
So I
be
didn't
okay with
attack
stuff.
you or tell you to do
No.
something or make you do something?
No, but you'd think that if somebody doesn't really want to look at you in the face, you wouldn't ask them questions like that. So,
I agree with you, I agree. So everything you said, you never did nothing against your will, you left on your own, you came back on your own.
correct.
The police grabbed you, and that's when you tried to reach out to me, so I can lie so I can get you out of your curfew.
Well, I was supposed to be going to meet you anyway, and I figured you were an adult, you could get me out of that curfew issue.
No more questions?
Ms. Collins, anything based on that?
Haley, do you remember whether or not the police called Mr. Davis at your request while you were standing there?
They might have. I'm not sure.
Okay, nothing else.
Anything else, Mr. Davis? Okay, Haley, so you're excused today. Please do not discuss your testimony with anyone else involved in this case until the case is over, okay?
That's perfectly fine.
Okay, thank you very much. You're excused.
Thank you.
Ms. Collins, apologize, I forgot, how many witnesses do we have left?
That's it.
This is it, okay. All right, so, so now is the time for argument in regards to whether or not the state's motion for other bad acts pursuant to the Franks decision, should be granted. So, while we are doing this, and Ms. Collins, I believe that you did this in your motion, but so I can have a complete record of what we are doing here. The state, pursuant to the Franks decision, the state must proffer its explanation of how the prior sexual offenses are relevant to the charged offense. For instance, how it tends to make it more probable that the defendant engaged in the charged conduct, and the court must then make a preliminary finding. So can you explain, can you put on the record your proffer as to why the prior sexual offense is, because it's two, are relevant to the offense charged, please?
Certainly, Your Honor. It's the state's position that this does go to propensity, consistent with the new statute. It goes to propensity because it shows defendants' willingness to engage in sexual activity with minor females in exchange for property or phones or money or weed. That is consistent with what the charged conduct is here. Vanessa Robinson was given money, she was given marijuana to allow defendants to touch her and also perform oral sex for him. So it's the state's position that it is relevant as it goes to propensity as well as, quite honestly, what motivates him. So that is my initial offer.
Okay. Now, another thing that the pursuant to LeMay, which is what the Franks decision cites to when we're looking at prejudicial effect, probative value, it discusses a couple of different things for the court to consider. Number one is the similarity of the prior acts to the acts charged, which I think you just hit on, but if you want to go in further, that's fine too. The closeness in time to the prior acts to the acts charged, the frequency of the prior acts, and the presence or lack of intervening circumstances. And then lastly, the fifth prong is the necessity of the evidence beyond the testimonies already offered. So if you wouldn't mind hitting the 5 of those for purposes of the hearing today.
Sure. So I think the similarity is evident to the court, and we have young females that, well, at least as to Erica Munoz and Ashley, who did not come today, defendant provided their transportation to Las Vegas. He got them a hotel room. There was communication. Ashley was actually the one that kind of drove that trip and brought Erica along. There was communication about sexual favors for the defendant for the defendant by Erica and Ashley in front of him, which at least he acknowledged by, I'm not going to hurt you, and he certainly didn't dispel anything that was being communicated in front of him. you know, that they were gonna get $1,000 if they allowed him to touch her, or $100 to sleep with them naked. So I think that is very similar to the situation that you have with the last young lady that testified for you. She was a runaway, similar to Erica and Ashley. She was a runaway. He solicits her on Fremont Street. He does actually very nice things for her. He puts a meal in her stomach, and he gets her a cell phone, and he puts a roof over her head. But all of that is ultimately in exchange for sex. And if the court remembers back the other day when we talked about this hearing, defendant even acknowledged that he had a phone conversation with Metro, and that was on the record. I don't know if we need to get that transcribed. They had a phone conversation in 2011 regarding this young lady and declined to talk to them and wanted his lawyer. So that's somewhat corroborative of that 2011 incident. As to the charged victim, Vanessa, in terms of similarity, Vanessa meets him. The defendant meets her at a fast food restaurant, befriends her, tells her, I don't know, that he will give her money and be nice to her, basically gains her trust over a course of a very short period of time. Then he starts reaching out to her very quickly thereafter, and under the guise of cleaning his house, he has her come over. And then clean my house is code for I want sex in exchange for money. So very quickly, Vanessa begins to give him oral sex for money. One occasion, she showers with a young lady by the name of China at defendant's request, where he masturbates in their presence. So the point being is you have defendant willing to exchange money, property, food, shelter, other things to these young women that are somewhat troubled and somewhat on the fringe, if you will, and that's kind of his pattern. So that at least shows the similarity of the prior acts. Closeness of time, 2004, I don't know where he gets that I said that there was a 2005 case. I've only said there was a 2004 case. I did previously say there was a Haywood, California case from 1998 or 7 that I cannot get the reports for because they've been destroyed and there's similar conduct. So I did say that. There is no 2005 case. 2004 to 2011 to 2014, 15 with Vanessa, there is a gap in time in there, but certainly I think the conduct is so similar, it kind of closes that gap. I mean, because the conduct between each of these young women is so similar in circumstance that I don't think any gap in time overrides its relevance or prejudicial effect for that matter. Frequency, there are a lot of young ladies that are coming forward with a very similar story. Defendant said there was no police report for Ms. Ferris. There actually is a field investigation card where she mentioned Ray Davis by name, but wouldn't give any further information. So that's how we found her. So there is a police report on that. I guess, in my mind, frequency isn't necessarily temporal, it's how many victims you're looking at. So we know that Ashley and Erica were here in 2004. We know that in 2011, we had Haley with her friend, who ultimately didn't commit an offense. And then here we have Vanessa and China that are named victims, and then another young lady, Adrian, that can kind of corroborate some of the things that were going on with Vanessa that she didn't participate in. So I guess in my mind, frequency should always also mean, in number. I don't know what intervening circumstances that there could be that would impute any prejudice to the defendant. Obviously his 2004 arrest and his ability to get out of that, nothing happened. That didn't shake him up enough to not quit approaching young ladies, but there's nothing intervening that I think the court could take into consideration.
That always confused me. Can you give me an example of when that's relevant? Like the lack of intervening circumstances?
I guess if someone's incarcerated. So if you have a 2001 act, and then somebody goes to prison, and then you have a 2010 act, and I guess that would be an intervening circumstance that the court should take into consideration. I don't know.
Okay,
I don't know.
okay. And then lastly, the necessity of the evidence beyond the testimonies already offered.
You know, I think this is necessary to the state's case for these reasons. Vanessa, it's going to come into evidence that she was in custody. You know, she was a kid that was troubled. I think her disclosure is compelling, but I think the similarity is going to lend credibility to her statements, especially based on the things that I see Mr. Davis trying to get into. So I think it's essential for the state to get to beyond a reasonable doubt to have these young women testify. I don't think it's prejudicial to the defendant because I think it is pure propensity, and I think especially to Ms. Ferris that we've given the court sufficient evidence to admit it. Do you have any other questions for me?
No, I don't. Mr. Davis, you have the floor. In
Yes,
regards to, during certain witnesses, you had some arguments to present, and so we'll always do those after the witness has, we can't just start arguing in the middle in front of a witness, so I'm happy to hear any of those arguments that you had previously had.
Right. Your Honor, Mrs. Erica Munez said, admitted she kept the Greyhound here. Then she told the court she went to Susan's house. Well, it's no way. The arrest record shows that I was arrested, I was staying at the plaza. So what's relevant in that whole instant is the Greyhound bus depot is 200 feet to the plaza. She would not catch a cab like she told this court. You will not catch a cab 200 feet when you get off the Greyhound bus depot downtown. The plaza is right there. You will walk to the plaza. You will not catch a cab. She told the court that she took a cab to the hotel. This shows that this witness was willing to lie. So I would like to impeach her based on that lie right there, and I would like her testimony just removed from the record. Because I prove without a shadow of doubt, without beyond a reasonable doubt, we can walk to the Greyhound bus depot right now, and the next hotel is the plaza.
But how do we know which Greyhound, how do we know which one she was driving or taking? You know what I mean?
Your Honor, if somebody's coming to Vegas, it's only one Greyhound bus depot they're going to. If I would like to know, I know she's over here Googling the other bus stations. Why would somebody get a ticket and go to a bus depot that's not at the same place that's right next door to your hotel?
I don't know. I'm just saying that wasn't in evidence.
So for argument's sake, say it was a different Greyhound bus depot. Where? It would have been in the police report. In the police report, if we bring that case up, it will say downtown Greyhound bus depot. There's only one downtown Greyhound bus depot, Your Honor. So, by Mrs. Munez saying that she took a cab from the downtown Greyhound bus depot to the plaza is all a lie, and she should need to be impeached, and her testimony needs to be stricken from the record because it's untrue. And I don't see anything that the prosecutor can say that as soon as she said it, I knew right there. I was like, why would somebody catch a cab from the Greyhound bus depot downtown? There's only one Greyhound bus depot downtown when they're 200 feet away from the hotel. Also, Your Honor, I didn't stay at the plaza maybe 500 times, 500 nights. The plaza has a policy of they will not give a kid a key. You cannot walk to the front and ask for a key. The bellman also will not hold a key for a kid. you not be a 13-year-old and walk to the front and say, I need a key to this room, can you give it to me? They would not do that. Also, if Mrs. Collins get the receipts, I'm sure the plaza keeps a record. This girl has no idea of what room she was staying in. And to say that it was one bed and they were gonna sleep, what if Mrs. Collins went and got the records and see there was multiple beds in the room or something? And then to say that she stayed 2 nights in part of her testimony, and then, but she was arrested this night. I mean, how can this testimony be admitted in a court when it's plainly see that if you say downtown Greyhound bus depot, she didn't catch a bus, a cab. She didn't catch a cab to a hotel that's 200 feet away. I just don't get that.
Okay.
So
Anything else?
that's the argument for her.
Okay.
Argument for Mrs. Haley. Mrs. Haley, I mean, it's really disturbing because I work with a lot of, I work with, say I volunteer quite a bit downtown with
Okay.
homeless. She's been snooping on my Facebook, so she can see, you can go back 5 years ago and see that I'm an advocate for the homeless, but I'm also an advocate for the Shade Tree, and I donate quite a bit of money to the Shade Tree. To see, one thing I notice is when people are on drugs, they're fidgety, they're nervous, they say things, they nod their head, all this stuff. I've been around a lot of drug users. Never did it myself. It was plainly clear to see that she wasn't in her right state of mind.
Well, I'm gonna object, he's not an expert, he can't make a record about his perception of her physical attributes or the way she acts. He doesn't know her, he hasn't seen her for that many years. He can't make a record that she is under the influence when there's no evidence of that.
And I've got to be honest with you, I was here, I watched her very closely both before you made that, representation and afterwards. I found her to be responsive to each of the questions posed by both you as well as Ms. Collins. There was never a point where she seemed confused. She seemed to be able to hear the question, understand the question, and then respond appropriately. So I do not make a finding, or even close to that I even found a suspicion that she was under the influence of anything.
Not knowing your age, Mrs. We can move on from the drugs or whatever,
Okay.
but not knowing your age when this incident happened supposedly on your birthday, and now you think you're 15 or 16, she would know she's 17 because I did the math myself. I know I'm 52. I'm sure your clerks know how old they are. So if somebody gives you some years, why wouldn't you say you think you were 15 or 16 when in fact you were 17 at the time of the incident? That shows that, the state is trying to make it look like I'm after these 14, 15, 16-year-old women. And then I go to the point of charges and convictions. I think if she had a conviction on my record, I think you could bring that into court. I would think you could, okay, Mr. Davis has been convicted of child molestation, he's been convicted of kidnapping. The jury should hear that.
So there are ways in which you can get someone's prior criminal history into evidence. There are specific statutes in the Nevada revised statutes in regards to what types of crimes you can impeach an individual on. So I'll need you to look at those before we start a jury trial. But for the purposes of this hearing, it really wasn't relevant in regards to the purposes of this hearing. What's relevant in regards to the purpose of this hearing is whether or not this evidence should come in for propensity purposes,
Right.
whether or not it's relevant, whether or not the state could prove this by a preponderance of the evidence, and then those 5 factors that deal with prejudice versus probative. So let's stick with that.
Yeah, so this would definitely prejudice my whole case. Because the simple fact is, she's bringing in something that's all hearsay or somebody said, but there's no convictions, there's no arrest for Haley. There's arrest for 2004, which she says by the grace of God, I walked. Well, I walked because the report showed all lies. During that 2004 arrest, the 2004 case, the reason why, and this is on the record, you can look it up. The day I was arrested, I couldn't have been there. I was at the final table in a Bellagio tournament where I ended up winning $67,000. The tournament ended at like 1 a.m. in the morning. So unless I left the Bellagio in between a tournament where I'm playing for hundreds of thousands of dollars, first place was like $200,000, and drove downtown and hung out with them. So once that never happened, they had no case, they dismissed. To say I kidnapped them when somebody plainly got on a bus and traveled on their own, that's not kidnapping. So I can understand Mrs. Collins want to put things in the jury's head that possibly she thinks happened. But let's put facts. Let's put what really happened. Let them know what I've been convicted of, not
So what evidence do you have in regards to the Bellagio and
Yes,
you were
I got-
there till 1 in the morning?
Yeah, you can go to my Hendon mob.
For what?
It's called a Hendon mob. It's a poker's players data, and it's called hendonmob.com. And then you just put in Raymond Davis, and it will show you all my results.
Okay, but how does that show me where you
Well,
were when
it
and till
shows
what
you-
time?
Well, it shows you a time of the tournament, and obviously, if you're deep in a tournament, it shows the date. It gives you the date of this event. So
So you were in Las Vegas on that date?
yes, I was in Las Vegas. Yes, I was in Las Vegas.
Okay. Anything else?
So, I'm just saying, Your Honor, that you're talking, this was just totally prejudiced the jury. It will stop me from getting a fair trial. And, you know, I understand how the judicial system works somewhat. If a person has been convicted of a crime, they can hold that against that person or whatever. But to hold something against a person that hasn't been convicted of a crime, I mean, that's the craziest thing I ever heard in my life. So this is something she wants to do. She wants to hold things against me that I've never been convicted of and have a jury hear this. I mean, that don't even sound right. You know, it don't even sound right that I would ever hold something. And also, I'm a very open-minded person. You know, I'm not judgmental at all. I think whatever people do is whatever. But I think if they're convicted of something, that shows. I don't think saying a person did something without a conviction, a jury should hear this.
Okay.
That's it.
Ms. Combs, a few questions. In regards to Vanessa, was Vanessa a runaway?
No,
But she was in and out of the juvenile criminal justice system?
that's correct.
Okay. And then in regards to Ms. Munoz, I know that she stated that, she gets in front of the defendant and she and Ashley are having, this conversation, about the $1,000 if he can touch them, $100 if he couldn't touch them. I didn't put in my notes, did she ever receive any type of payment?
No, she was taken clothes shopping and Wet n Wild, but she didn't receive any payment.
Sorry, not Ashley, but, Erica.
Not that I'm aware of.
Okay. And then Ashley, the state does not have as a witness, correct?
No, we do not. Ashley, upon contact, says she doesn't remember anything.
Okay.
I do have an offer of proof, though, just very briefly, if I might.
Sure.
Since he is concerned whether or not this, happened at the Plaza or Caesar's Palace, whether he was there or aware. This is, first of all, what did culminate in the 2004 case, but just from the police report, the security staff at the Plaza Hotel located Raymond Davis, who is a well-known poker player inside the Plaza Hotel. He was asked to speak with police. I spoke with Raymond, who was placed in handcuffs and under arrest. Raymond related the following. Raymond said that he had legal custody of Ashley and that Ashley's mother wrote and signed a letter saying that he did have custody of her but had no court documents. However, he did leave the letter that Ashley's mother signed in California. Raymond admitted to buying Ashley and her friend Erica bus tickets from California and that rooms at the Plaza Hotel were comped. Raymond told me that he slept on the couch inside the room and not on the bed with Ashley and Erica. So that's technically, I guess, part of my offer of proof for the case. I can have an officer come in and testify to that. So just if there's any concern with the court that the 2004 case didn't happen or there's transportation inconsistencies or hotel inconsistencies, Mr. Davis was there in custody, under arrest, admitting that he had supplied the bus tickets for both young ladies and got the comped rooms at the Plaza. So he kind of clears all of that up.
No, that clarifies a lot for me, because I had questions in regards to that. Yes?
You know, also, when the officers came in contact with me, they didn't find me in a hotel, downstairs in a hotel. I was in bed at 3 o'clock in the morning. There was no one in my room when the officer came. I would love for her to bring the officer in to get on the stand and say this herself instead of her saying that she could bring the officer. If she can bring the officer in the court, she should have brought him. She brings 2 witnesses when she got a list of about 8 of them that have, that neither one of their testimonies, one perjured herself by lying, which, I mean, where's the officer? Where's the officer that did the police report, the statement, where is he that he can, that's all I want to know is where's the officer?
Okay. All right, so in regards to what the court needs to find, the court needs to make a preliminary finding that prior sexual offenses are relevant for propensity purposes. I mean, obviously, these are relevant. The real question comes down to what's the prejudicial effect versus the probative value. I find that the jury could reasonably find by preponderance of the evidence that the prior conduct did occurred. In regards to Miss Munoz, there were several times when she stated she didn't remember if she were trying to fabricate or she had a motive to fabricate. She could have easily went along and said, oh yeah, that happened, he was there watching us in the shower, but instead she didn't do those things. She said she doesn't remember why they jumped in the shower together. She says that the defendant wasn't there, didn't ask them to do that. She's very clear that when she was having the conversation with her friend, Ashley, so it's Erica Munoz and Ashley, when she's having the conversation with Ashley, Ashley's talking to her about what they're going to do. She begins to cry, the defendant begins rubbing her arm, and the defendant is telling her everything's going to be okay, and there's this conversation that Ashley's going to do this stuff and that she's not, and that the defendant had discussed with them, and Ashley had regurgitated basically that it's $1,000 if he can touch them, $100 if he can't. I find this to be relevant for propensity purposes because when you look at that information compared to the information here, we have runaways. Basically, we have, in all 3 cases, we have girls who have troubled past, whether it be a group of runaways or girls who don't have proper supervision that are in and out of the criminal justice system, where the defendant meets them, befriends them, provides them services like a cell phone, a place to stay, money in exchange for basically touching them inappropriately or sexual acts with them. We have that same type of thing in the 2011 case with Haley, where we also have proof that she was there basically where she said she was going to be because we have this contact with the police, we have this FI card. Going back, we also have police contact in the 2004 case because we have police contact with the defendant in this same area during this same time period. So, same thing with Haley. We have a runaway. The defendant approaches her, offers her things that she needs, a place to stay, food to eat, marijuana. When she gets up there, promises are made to get her those things if she does what he wants, and so she does. Again, oral sex, which is the same that we see in the case that we have at hand with Vanessa. So when I look at the similarity in the conduct, we clearly have a propensity purposes issue going on here. So what that leads us to is, lastly, when we look at the probative value versus the prejudicial effect. I already discussed the similarity of the prior acts to the acts charged. When we look at the closeness in time of the prior acts, we have 2004, 2011, and 2014. So I think there's a continuous conduct with the same type of conduct, specifically with girls that are in trouble who are needing certain things, and those needs are provided for them. In regards to the frequency of the prior acts, again, it's 3 different acts within 10 years of each other. I will note that it was either the Franks case or the LeMay case, that there was a 12-year gap, which states that that doesn't automatically throw the prior bad acts out. It's just a factor that can be considered. The necessity of the evidence beyond the testimonies already offered. So this is basically a he said versus she said case. It's my understanding that there's no DNA, no fingerprints, no video, and that it's not a consent case. It's actually a purely he said versus she said, where the defense is it did not happen. Is that correct?
That is correct.
So those are the precise type of cases where both Franks and LeMay discuss that this is the type of case where this can be appropriate. So in considering all of those factors, I think the state has met their burden that was described both in Franks and in LeMay. So I want to get into the specifics that actually can get into Ms. Collins. So the fact that the bus tickets were bought and paid for by the defendant, the fact that both girls were runaways. The shower cannot come in because there was not any evidence or any testimony that Mr. Davis had said anything about that. And then obviously the conversation that was had in his presence in regards to the $1,000 and the $100 and one of them crying and him rubbing their arm. And the regards to them sleeping all in the same bed that night and then Erica leaving. And then in regards to Haley, Haley testifying to the fact, Haley's testimony, she basically testified to everything that you said she was going to testify to. So the fact that she was panhandling, that he told her that he befriended her, told her that he would get her something to eat, he did get her something to eat, he provided marijuana, he provided a hotel room, provided a cell phone, the oral sex, an agreement to do something sexual later, but then she gets picked up and she's on the phone with him when she gets picked up, and then she can't make contact with him after that.
Understood, Your Honor. And just so the court knows, we did not realize that Ashley would be uncooperative.
Right.
The motion was drafted.
Understood.
Okay.
All right, so if you could please have an order, though, prepared in regards to the oral findings that I just made, I would appreciate that. And then if you need, I know I talk fast and I talk a lot, so if you need a copy of if you need a CD, so you can put that all in order, I'm happy to provide it.
I think I can get it handled.
Okay, so with that being said, we will start trial tomorrow at 1:30 in picking our jury. Anything to address before we get the jury here?
Yes, Your Honor.
Yes.
I'm gonna object to your ruling right now. I want it on the record that I object, because you yourself said offenses. How can it be offense if nobody was charged? If it's not on the record, how is it offense? How can someone say you did something, said something, not get charged for it, and you say, okay, we'll let them hear that, but you have no charges for it?
So
What country am I living in?
okay, so let me explain it to you. What the law says is that other bad acts can be, sir, your cell phone should not be on, and you should not.
It's not on.
Well, then why are you looking at
I
it?
mean, it's not ringing.
So what the law says is other bad acts can come in for propensity purposes if certain factors are met. So you don't have to be charged with a crime. It's referred to as other bad acts or other act evidence. So you don't have to be charged, you don't have to be convicted. It just has to be a previous act or an other act. And then the state has to meet those burdens or prongs that are established in both the Franks case as well as the LeMay case.
So the fact that she sat here and told you that she took a cab to the plaza, which was 200 feet, that had no bearing on her statement?
I think it totally has bearing, and I gave it the weight that I deemed it appropriate for the credibility. I also recognize that that's something that you can definitely bring up and cross-examine in front of the jury. But as far as my findings, it doesn't affect the overall conclusion of my findings.
Thank you.
Thank you. We'll see you guys tomorrow at 1:30.
Your Honor, just very briefly, before we take off, if you don't mind.
Yeah.
When I arrived here earlier today, Mr. Davis was present. Mr. Klaus was not here yet. I extended an offer to Mr. Davis. I just want to put that on the record. For clarification, the offer was 1 count of soliciting prostitution from a child. That's a Category E felony, mandatory probation.
Okay. And you received that offer?
I didn't receive nothing, a verbal, I would like to see that in writing, so.
Okay, well, so it's plead guilty to an E felony of no opposition to probation. Are you choosing to accept that offer or reject that
Oh,
offer?
no, I'd like to see it in writing. Can I see this in writing?
No, that's not how it goes. It's an E felony. Does that require sex offender registration?
It does.
Okay.
And we had that conversation, and he specifically rejected it.
Okay.
Okay, Your Honor, if somebody's giving an offer, I would like to see the offer so I can look it up and see what it entitles me, it does to me. So,
Okay, so I think Ms. Collins explained to you, it's an E felony.
I don't even know what E felony is.
Okay, it's the lowest type of felony there is in Clark County.
That's C?
E, elephant, no opposition to probation. You do have to be registered as a sex
Now,
offender.
what do you say about the probation?
You would receive probation.
Yeah, I would see.
So you would be a convicted felon, you would receive probation, and you would have to register as a sex offender, so you would be a sex offender.
And we had that
Look it
conversation.
up, just look up E, so not to make you think I'm using my phone.
And it's a recent amendment that makes it an E, so it wouldn't be solicitation during the time frame. I
Okay.
apologize that he can actually did these things, it would be current legislation.
Got it. Are we done?
Yeah,
Okay.
I'm done, Your Honor.
Okay, so I'm sorry, you're rejecting that offer.
Oh, yeah, I don't even know what it is.
This is the
Your
problem
Honor,
I have with you, it's like,
Your Honor,
What
can I
did-
have 10 minutes to look at it? Can I look at it for myself?
yeah,
I
what
mean,
do you
that's
wanna
all-
look at?
I mean, if the court is offering something, I think I should
I'm
have.
not offering anything.
I know, if the DA is offering something, shouldn't I have a chance to look at it?
But what would you like to look at?
I would like to look at the rules of it. I've never been on probation, I've never been a sex offender, I've never even been on this. I wanna see what it does.
You know what, I don't mind that. Here's my issue with Mr. Davis. We have this conversation in front of your marshal, in front of my investigator. He's flippant and he rejects it. Then he acts like on the record that somebody is doing something to his detriment. Nothing to his detriment has been done. He flatly rejected it, did not want to discuss it. Now he acts like he wants to discuss it. So if he wants to go look up the law for 10 minutes with Mr. Klaus so we can come back in here and make a record before jury selection tomorrow, I'm fine with that. But what he just told Your Honor does not in any way reflect the conversation that he and I had in front of my investigator before court today.
Okay, so would you like 10 minutes to go look at everything?
Yes.
Okay, so we'll be at recess for 10 minutes. Just come get me when you guys are done, we'll go off.
Thank you, Your Honor.
Part of the JC, so sometimes they will, just to help you out, because that's what I did. And then if they change them up, so that you'll know all the dates clear. I don't know if I'm supposed to tell you that or not.
It's okay.
Well, I heard you guys.
We're 1:30. Oh, I forgot I have to
See, that's how we were trained. If you didn't know, then it was like a while longer than you could just kind of, that was like 15 years ago. Especially when you don't know what they're on. Yes, sure.
All right, we are back in the record in the state of Nevada versus Raymond Davis, C 342946. Mr. Davis is present out of custody. Mr. Klaus on his, well, Mr. Klaus present as standby counsel. Ms. Collins on behalf of the state. All right, Mr. Davis, did you have the opportunity to look the items up that you wanted to look up or discuss? Any questions?
Yes, Your Honor, and although the court thought it was easy to understand this, it took him a lot of research to look at exactly what was offered to me. So it wasn't like I was
Okay,
like,
you don't, just let me know. Did you do what you needed to do?
yeah, yes, he did what he needed to do about that.
Okay,
And he explained everything to me.
okay. And,
I rejected
okay,
state's offer.
so did you have ample time to consider what you needed to consider and look into what you needed to look into?
Yes, he showed everything to me.
All right, and you're choosing to reject that offer?
Yes, I did.
Okay, so we'll see you guys tomorrow at 1:30.
Yes, ma'am.
And I apologize, this is something that I need to put on the record. Is that offer now revoked?
Yes.
Okay, all right. See you guys tomorrow at 1:30.
Thank you.
Thank you.